I'm Andrew Rapaki, and I'm excited to talk to you today here about our webinar on mastering IP strategies to protect your AI inventions. First, I want to get started, and I want to thank everybody for joining me. I know we have a long weekend coming up, and I appreciate you being on here, and I hope I can answer any questions you have. We're going to have a Q&A at the end of the webinar, and we're going to answer as many questions as we can. If we don't get to your particular question for any reason, I promise that I will write you back with an answer or pick up the phone and give you a call. Okay. With that being said, let me get started. I'm Andrew Rapaki. I'm the managing partner at the Rapaki Law Firm. Um, before becoming a patent attorney, I was fortunate enough to serve my country as an engineering officer in the Navy. Um, I went to the U.S. Naval Academy for undergraduate and Florida State for law school. On the webinar today with us is Ken Brooks. I'm going to give him the floor to introduce himself as well before we get started.
Sure. Thanks, Andy. I'm an associate patent attorney here at the Rapaki Law Group. Been practicing patent law for about 8 years now, a mixture of law firm practice and in-house counsel for software companies. Went to law school at Detroit Mercy University and Michigan Technological University for my undergraduate.
Excellent. Thanks, Ken. All right. With that being said, let's get started. I'm going to try, and my plan today is to get through the PowerPoint in about 35 minutes so that we have enough time for Q&A. Okay. All right. So today's topics, I want to start off by talking about recent AI trends and kind of historical AI patent filings. Okay. We want to talk about types of IP for protecting your AI innovations. Patentable subject matter in AI, right? Always a very sensitive topic. We're going to talk a little bit about the patent process. I've included some patent drafting tips, some do's and don'ts. I've included some patent claims in here that I'd like to talk about that include some good and could be better information, as well as drawn figures. And then I want to close by, what is AI doing for society today? Okay. And then questions and answers. Okay. So, as everybody knows, AI is really the hottest topic in the news in our everyday lives, right? It's permeating just about every industry. And it is really the hottest topic. In the software space, it's really become either you are a AI software or you're not, right? So AI has really taken over, and we're seeing that in USPTO filings and just about every headline in the news, right? So just to give you an idea, from 2002 to 2018, the historical data of AI patent filings just about doubled to about 60,000 annually, and that was to 2018. And you can see our graph here showing the number of applications growing every single year, and relative to the number of filings at the USPTO. Okay, from 2020 to 2022, last year we saw that number double. Right, so we are seeing an explosive growth, an exponential growth in AI related patent filings here in the United States. Okay. And that number is well over 100,000 applications every single year. And we'll talk a little bit about that as we get into some of the examples. Okay. So when we talk about IP for AI, there's several different forms of intellectual property protection available. The majority of AI is going to be protected with a utility patent, right? And when we talk about a utility patent, what are we talking about? We're talking about protecting the functionality of what your AI is doing, right? That software, when an input is put in, what's the unique output we get? So we're talking about the processes and the methods of your utility patent. Okay. To give you an idea, in the United States, there's two types of utility patent applications available. Okay. There's a provisional patent application. A provisional patent application is designed to be a placeholder that provides protection up to 1 year Okay. Often you'll hear people talk about it being the patent pending application. It's an application that's good for 1 year. What you need to understand with a provisional patent application is that it's never going to mature into a issued patent. It's simply a placeholder until you can file a non-provisional. That placeholder is valid for up to 12 months. Okay. The uh, the the application that will be substantively examined and result in an issued patent, if granted, is going to be your non-provisional patent application. Right? Your non-provisional patent application, you're probably familiar with when you watch shows like Shark Tank. They'll say, "Oh, I have an issued patent." Most of those are going to be issued utility patents that get 20 years of protection from the filing date. Okay. Other ways that AI is protected, right? If you've got unique graphical user interfaces showing some of your AI innovation, you can protect those with design patents, right? Design patents is a little bit different from a utility patent in that what we're protecting is the ornamental appearance of that graphical user interface. What is in that? The four corners of that. Design patents will include both broken lines and solid lines to designate claim subject matter. A design patent provides protection for 15 years as opposed to a utility for 20. Okay. Trademarks. Trademarks are a way of protecting the name, the likeness of your particular brand, right? So when you think about some of our big AI software companies, we think of Microsoft, we think of Google, we think of NVIDIA. Those brands, those whether they're the name itself, what we call a standard character, or the logo is going to be protected with a trademark. Okay, then lastly, software code, as we always talk about, that source and object code can be protected with a copyright. Okay. Right now, I want to focus on patentable subject matter, and the bulk of our discussion today is really going to be around how to patent and protect AI with utility patents, right? So, according to the federal statute, any invention is considered patentable subject matter if it's new and useful, it's a process, machine, manufacturer, or composition. Okay, the invention has to be new and useful or an improvement thereof. Okay. When we talk about AI patent filings, we really want to be talking about the practical application, the how of how that AI is implemented, right? How is that data selected? How is that data processed? And how is that data used? And how is it put into practice? Okay, an invention has a practical application if it's targeted towards a specific technology, a business, a vertical, or in the fintech space, targeted towards solving a financial problem. Remember, with any patent, and the issue with software is if the software is not correctly drafted and claimed, you're going to run into a 35 USC 101 abstract rejection. Okay. Typically with software, the most common type of abstract rejection you'll see is that a rejection will state that the software is simply organizing human activities and is not patentable subject matter because it's too abstract. Okay. Novelty. Remember, for any patentable subject matter, whether it's AI or it's anything, it has to be new and novel, right? What does that mean? It means that it cannot be previously offered to the public, described in a written publication, or patented, right? Remember, once an invention is disclosed in the public domain for over 12 months, it's no longer patentable subject matter. Okay. It's got to be non-obvious, right? When we talk about obviousness, we're talking about that the invention can't be an obvious combination of one skilled in the art, right? You can't put two well-known inventions or two well-known elements together to create a new invention. That's just not patentable subject matter. Okay, what should you be thinking about in terms of your specific AI? So when we're talking to clients on the phone, right? Our clients are going to say to us, "Okay, what should I be thinking about? What are the features or what is it in my AI that I should be thinking about?" Right. Well, the first thing you want to do with any patent when you're doing a disclosure call is talk about, okay, what's the novelty right? What's that point of novelty in your software? What's that point of novelty in your AI invention? Meaning, what is different about your system? What is new and novel and non-obvious about your system that's not disclosed anywhere in the public domain? Okay. Generally, when you're looking at AI or software systems, you're thinking about proprietary features or proprietary functionality, right? What's the unique functionality that your software, your AI executes, right? What is it when I put an input in that creates a unique output, or that unique process that creates an output? Also, you want to be thinking about what is the technical improvements that your software or AI provides over existing technology, right? So if you could talk about existing technology, you could talk about where that existing technology is deficient, and you could talk about where your technical improvements are. That's one way of drafting an application. Okay. The other thing that you need to be thinking about a lot when you're filing and drafting and filing your AI invention, and really in your disclosure call with your attorney, is how do I apply my AI? Right. When I take this data set and I put that into a node, or I input that in, what is the resulting output? Okay, so we really want to look at, okay, from the back end of the neural network, what is happening, and what is the practical application that this AI software conducts and solves. Okay, when we talk about specifically AI software, we want to think about a couple of different things. We want to talk about foundational models, right? Large artificial intelligence modules trained on a vast quantity of data, scaling results in a model that can be adapted in a variety of tasks and in a variety of verticals. Okay. Typically, your big modeling AI systems you'll see by your large technology companies. Okay. Um, Again, your adapted models generally are models that are used by your smaller companies, startups, and medium-sized companies that specialize in adapted models. Okay. Patentable adapted models create a competitive advantage. If you can find that point of novelty in that adapted model, that will really help you to draft the best set of claims, and then also to receive that notice of allowance and issue patent. Okay. Remember, the adapted models typically must meet the practical application requirement, like any AI patent. Okay, let's talk about from a large from 10,000 foot view. What's the process when I'm thinking about preparing and filing my AI patent? Well, you want to start by conducting a prior art search. Okay, I always tell clients a prior art search is going to tell you if your invention is patentable or not patentable. A really thorough prior art search is going to take it a step further and give you an idea of of the patent landscape, meaning how many similar inventions are in this space, right? If I can understand how many similar inventions are in the space, now I can kind of tailor those claims, whether that be broadly drafted or narrowly drafted, so that they can get through the U.S. Patent Office examination. Okay. Obviously, with any application, we need to know the point of novelty, right? We don't want to talk, generally speaking, okay, my invention has AI in it, and that's why it's patentable. No, we need to understand what's that point of novelty and how is it practically applied, right? Once we can understand, once we've conducted a prior art search, we understand the patent landscape, we understand how broadly or narrowly we can draft that application. Okay, now we can get started with the patent application. Okay, best practices when drafting an application is to thoroughly describe all your systems, your processes, and the components involved. Right? You don't want to speak generically. You don't want to speak broadly and use generic language, or just briefly mention, "Hey, my AI model is the point of novelty." That again is going to be considered too abstract, and it's not going to result in an issue. Okay. So we want to avoid generic language. We want to avoid reciting generic components. We want to really get into the nitty gritty of the systems, the subsystems. Um, we want to talk about, extracting data from inputs in the neural networks. And we want to talk about the recited features within that particular AI patent and how is that AI applied. Okay, we want to avoid language that could be considered methods of human activity. What we briefly talked about being too abstract. Okay, um, in ways to avoid abstract in 101 rejections, we'll discuss a little bit when we talk about some good examples here. But again, we want to avoid genericness. We really want to understand the novelty. We want to hone in on that novelty. And we want to talk about, what that AI model is doing. How is that data being used in the input? How is that processed data um, used within that AI model? Okay. We also want to talk about, if we can incorporate examples of how your AI model meets the practical application requirement, that, is absolutely a necessity when drafting an AI patent. Okay. Also, you want to talk about drafting your claims to um, recite both the system and method, right? You want to avoid talking about software systems by themselves without introducing the hardware components, or you're going to have a greater chance of receiving a 101 rejection. Okay, so within the application, whether it's in the claim center, the specification, or even the drawing figures, right? And you don't want to discount the value of great drawing figures. We want to make sure that we can show computer architecture, systems architecture, neural networks. We want to talk about functionality. We want to talk about the components that the AI or the software is recited in. That's going to help us avoid that 101 rejection. Okay, let's talk a little bit about when you do receive word back from the USPTO. So you're gonna file your non-provisional patent application, and you may receive an office action rejection. That office action rejection can include two things. It can incorporate objections. Generally, those are what we call 35 USC 112 rejections. Um, Again, you overcome those formalities by amending some of the language in the claims that may be considered indefinite. Uh, Generally very easy to do. Rejections, on the other hand, there's three types of rejections. Obviously, a 35 USC 101 abstract rejection is going to require the two-step analysis to overcome. Okay. Also, a 102, 103 rejection, right? Again, 102 rejection, we call that an anticipation rejection. Like essentially, the examiner saying, inventor, um, your application is rejected because there's another reference somewhere in the world, whether it's a U.S. or foreign patent published application, a piece of non-patent literature that recites exactly how your application functions. Okay, that's considered a 102. You would address those primary references and overcome or traverse those primary references in your amendment. Okay, 103, we call that an obviousness rejection. Very similar to 102. Instead of it being a single reference, the examiner is going to combine two or more references to say, in combination, these two references recite what your invention does. Again, the analysis is going to be with a 103 to attack the primary references and traverse at least one of the primary references. Okay. Um, how you reject, how you address a rejection can be a number of ways. You can simply argue that the references, fail to disclose a certain aspect, element, or functionality of your invention, or you may have to amend the claims. Okay. Remember, USPTO examiners make a rejection determination when the issues involve the merits of the claims, right? The substantive elements of your claims. Again, if you've received non-finals, finals, and you don't believe that the examiner's arguments are valid, you have the right to appeal to the Patent Trial and Appeal Board. Okay, so let's talk a little bit about patent drafting do's and don'ts. Okay, before we get into some AI examples. Okay, as I said before, the foundation of any application is going to be identifying the novelty, that point of novelty in your invention. If you cannot clearly recite that, okay, your chances of getting a patent are very low. right? You want to be able to not only tell your patent practitioner, whether that's a patent attorney or a patent agent, what it is your invention does, but here's the actual point of novelty, right? And sometimes finding that point of novelty requires a couple of disclosure calls back and forth, right? Again, having a fixed fee model allows you to get on the phone with your practitioner and not have to worry about the billable hour approach. Okay. We want to talk about, okay, how your AI software improves computer hardware functionality, right? What's the technical improvement that your software does, right? We want to talk about, and we've kind of hit on this already, we want to describe in detail all the systems, the subsystems, and components of your software, right? We want to avoid that generic functionality, that generic description of components. We want to avoid, language where we're simply automating something that a human can do. We want to avoid automation without any sort of practical application, right? Those are going to trigger your 35 USC 101 abstract rejections every time. What I would also tell you to avoid is do not describe, stay away from simply using language that, hey, my AI, AI is used in this system. If you're not describing how the AI is used, what that AI practical application does, you're going to have a very, very hard time receiving a notice of allowance, and you're going to likely receive a 101 rejection. Okay. So remember, this presentation is really about how to best describe and incorporate your AI and how to protect your AI invention, right? So we want to take it a step further than simply describing an AI model. We want to talk about what aspects within that AI model are really key to creating that novel that novel AI practicability. And in a minute, you're going to see, I've included a couple of USPTO examples of patentable technology within the AI system. Okay? These examples are not exhaustive. There's many, as you saw before, there's many AI applications being filed every day. And these examples are not limited to a specific vertical. Again, I pulled examples that I thought were well drafted, and I'm also going to include some areas where I think they could be improved. Um, Again, we want to talk about the novel pre-processing of model training data. That's an example. That's our first example. We're going to talk about model training processes. Um, and that may include generating unique data sets prior to training an AI model. The second example we're going to talk about includes systems where specific algorithms are used. Okay. So let's get into some good claims and some issued claims and some examples that are available to USPTO. Okay, so our first example here is a novel use of an AI model, right? And I include this model, and I include this example. It's titled "System, Method, and Computer Programming," or computer program for operating a multi-stage artificial intelligence analysis in a communication network. Okay, this is an example of a claim that it was filed in 2019, resulted in an issued patent in March 2021. Okay, what I like about this is really the first element of this claim, right? We talk really. This is the first element of this claim is a great way to avoid a 35 USC 101 rejection. And that is, we really talk about what's happening within the processor, right? So here, acquiring using a processor of a communication network, first log data of a network activity of the communication network based on a first set of monitoring rules, wherein the first log data is of a lower level of resolution by including a first number of log events associated with a particular length of time. Okay. So what I really like here is I think this is a great example of clearly communicating what's happening within the processor, right? It's going to be very hard to say that this is simply reciting a generic functionality or abstract functionality when we talk about the specific things that are happening within the processor. Okay. Um, I like in here, in the second or in the first bolded portion, it really talks about computing a confidence level associated with detection of a network situation, wherein the confidence level corresponds to an AI model used to detect the network situation, right? So I really like, okay, so this is a kind of a example of an earlier AI system where they talk a little bit about the AI model. They don't get necessarily in depth with it. Okay. But I like what they're doing in the processor. And then I like what they're talking about the AI model. Remember, I want you to keep in mind this is a 2019 filed application. Okay. What you'll see is, what you'll see as we evolve through these different claim examples is um, this one could include more about what inputs are being used in the system in the AI model, um, what's happening within the processor, um, and get a little bit more specific in what the AI is doing. So maybe a little more AI practical application here. Um, Again, like any patent drafting is always a dynamic. Uh, it's a dynamic exercise, meaning applications that were filed in 2017, you know, if filed in 2023, may not pass muster, may not resolve or um, become an issued patent, right? So again, 2019, this resulted in an issued patent. Okay. Um, and there's some things I like and some things I don't. Let's take a look at the second example. Okay, so this one is titled "On the Fly Deep Learning and Machine Learning at Autonomous Machines." Okay, this is an Intel issued patent. Okay, this application has some good information in terms of extracting data. Okay, and then what happens with that data in terms of the training. Okay. So we talk here. What I like here is the idea of extracting via deep learning framework a feature learned by a first deep network, a neural network model. Okay. And then the second element that I like here is training that extracted data via the deep learning model. Right. So here we get a little bit more granular and we talk about the data that process data that's pulled and what's happening with that processed data. Okay. Um, what I think could be improved here. It doesn't really tell you where this data, what happens with this data after it's used. How is the data collected? How is the data processed? When that data is put into the input, what happens next? Okay. I want to go to the third example. Okay. Again, I'm using a Sony patent, an issued Sony patent titled Artificial Intelligence Model Training Using Cloud Gaming Network. Okay. Here, I think this takes it a step further. And this talks about training an artificial intelligence model, right? So we like that. So we're talking about actually training the model and practicability of the AI model. Okay. I like how they talk about applying the input state data to the AI model to determine a predicted degree of success. Okay. Um, and then I like providing a recommendation, right? So now we talk about what happens with that data. Okay. One thing I would add to this example that I think could have been drafted a little bit better is to talk about, where are you getting the data? How is the data processed? Okay. Um, Again, simply using language like I'm training an AI model uh, would not likely be issued now in 2023 with the number of AI inventions that are being submitted to the USPTO. Okay. So I think this is a good example of kind of the evolution of patent drafting in AI. I think this is a good example of talking about the actual AI model and its practicality. I like how it talks about a little bit about data input. I like how it talks about what happened a little bit with that data input. Um, what I would like to see is how is that data collected? How is that data processed? Right. So we don't really talk about where is this data collected, where is this data processed. But again, I think this is a great example of a patent that resulted in an issued patent. Okay, I want to talk about AI figures. Okay, um, so when we talk about AI, we really talk about people often overlook the value of AI drawn figures, right? When we talk about AI drawn figures, there's really 5 different figures I like to include in an application, right? I like to have a network environment, right? Where we talk, there's 2 different variations of network environments. I like to talk about, I'd like to have a figure in there of the server or node where the method is executed, right? I'd like to have a flow chart for an independent claim. Okay. I'd like to have a second flow chart that show what the dependent claims are doing. Okay. I'd like to have a computing system diagram, right? So again, that network environment is really valuable in the sense that we can kind of show where is this data collected, how is this data processed, or what's happening in the neural network behind in the back end of it. Here's one example of a drawing figure that I really like. Here we talk about training a data set. We talk about the neural network in here. Okay, so here we're talking about data inputs. We're talking about what's happening with those processed data, right, and how it's being trained, and then we talk about the result. Okay, so I like this example, and I think this is a good first example. Okay, this second example is a flow chart, and this is an example of something that you would include to talk about the process that your software is conducting, as well as the independent claims. Here on the left is an example of a graphical user interface to show if you were to file a design patent, what would that design patent protect? Lastly, before we get into the questions and answers, I just want to talk to you a little bit about, the explosion of AI and what that does for you as an inventor in your company, right? So protecting your AI gives you the right to exclude, right? So that means that you have the exclusive right to sell, offer for sale, make, use, um, or offer for sale your patented subject matter, right? When we talk about AI and we talk about software, we really talk about your ability to license that technology, whether that's in a conventional software as a service model, right, where you're collecting monthly or annual recurring revenue, your ability to sell that technology, okay, or your ability as a company to just offer it to your customers. Okay, AI inventions and software inventions are going to help you build a portfolio that's going to create a barrier to entry, right? But it's also going to provide an ability to license out that technology. Okay. For those that are fundraising or are a new startup out there, right? Having a AI invention, having a issued patent, even a pending patent demonstrates to potential investors that you've taken steps to protect your invention. Okay. Remember, issued patents are 20 years from the filing date. Okay. And provide an ability to a defensive barrier, that barrier to entry to keep competitors out and provide a competitive advantage, as well as licensing. I want to start with the Q&A. So if we have some questions in here, I'd like to get started there.